to the Legal Insight podcast by HHQ, and we're in our new series called the ESG Imperative, where we explore how law, governance, and accountability are reshaping the way businesses operate. This is part 2 of the podcast, and if you've not watched part 1, I highly suggest that you watch part 1 to understand the fundamentals of Section 17A. Now, in part 2 of this series, we explore how directors and what directors and senior management must do to protect their organizations. I'm joined with Ankit Sanghvi, the partner and head of ESG and construction practice group at HHQ, and also Cynthia Gabriel, the partner at Cynthia Gabriel Associates. Welcome to the show.
Thanks, Zach.
Thank you.
Now, we will start with a brief introduction of Section 17A. Maybe, Ankit, for those who have not actually watched part 1, you gave a brief rundown of what Section 17A is and why is it important for directors to take notice of this.
Sure. So we have obviously, as you mentioned, discussed this during the last session, but if I could just summarize it, Section 17A essentially is a provision under the MACC Act, which can put commercial organizations into serious trouble if they have committed corrupt acts. We have also discussed previously that the MACC Act traditionally, and the way it was first framed to catch individuals, but now with the introduction of Section 17A, companies can also face such liability or be open to such corrupt charges. Now, when I say company, one would ask, or one would think, how can a company be charged? Who then is the person who's committed the crime? The law actually is very far-reaching in the sense that the directors, the managers, and even high C-suite people within an organization would all be caught within the meaning of Section 17A as associated persons within the company. So it implicates all of them, higher level management. They are deemed to have committed the same offense that the company has. And the only way they can defend themselves is to ensure that they are able to demonstrate in court by way of a defense that they had in place adequate procedures, that they have exercised proper due diligence to prevent the type of offense from occurring. However, it still occurred. That would be the only way one can defend itself now.
Thanks, Ankit. Now, Cynthia, we have heard of how serious the offense is and who can be implicated, but in reality, have we actually seen Section 17A enforced?
Well, it has been enforced. And so this is the message that needs to go out clearly, that it is being enforced. And so all companies, big or small, that fall under the bracket of Section 17A needs to be prepared. So we have the first reported cases of Section 17A of Pristine Offshore, Sandra and Berhad, which was a company charged in relation to corrupt payments linked to contract and logistics. So it's a good case to actually start thinking about how we want to look at lessons that we can pick up from improving our own trust systems, improving our own defense mechanisms to ensure that if we get into some kind of entanglement with the authorities, we are able to show that we have a good policy in place. But despite that, it still happened. I think very interestingly, you will remember how the UK Bribery Act was also actionalized and implemented, where several airlines were implicated, including our own airline. So here I won't mention any names. But the airline that was implicated, which is Malaysian-based, was also implicated under the UK Section 7 Act because it was a company registered in Malaysia but operating in the United Kingdom. So similarly, we have a couple of local cases here that Section 17A can reach you, the long arm of the law, to actually look at where lessons are. But it's also important that it should not exist only on paper. So how does it actually get actualized? For me, is a question that I think HHQ and several professionals can actually help to answer.
Sure. Now, you mentioned the long arms of the law. Does Section 17A actually extend extra-territorially? As you mentioned, the UK Section 7 Act actually extended to a Malaysian company operating in the UK. Does it work the same for our law as well?
Well, we are a little bit cut and paste of the UK Section 7 Anti-Bribery Act, which is totally fine because the winning point is really we have Section 17A now. But if you look at Section 8, the definition of a commercial organization defines the scope to include companies, partnerships incorporated formed under Malaysian law, or foreign companies, partnership carrying out businesses in Malaysia. So, as I mentioned just now, like a plantation company operating in Indonesia but registered here, Section 17A does apply to them. So I do recall that there were a couple of lawyers trying to take up a case on the annual haze.
Yeah.
You know, the forest fires that we suffer every year around August, September, right? So it's about which Malaysian companies were operating in Papua New Guinea, Kalimantan, and it is very possible to apply Section 17A in this context.
Thanks, Cynthia. Now, Ankit, looking more broadly, are there any major corruption cases that illustrate why corporate accountability actually matters these days?
I think, as Cynthia mentioned, the case of Pristine Offshore, perhaps I'll just touch upon that a little bit. Pristine Offshore was actually the first commercial organization in Malaysia to be charged under this Section 17A offense. The allegations were quite simply this. One of the company, in association with its former director, was accused of giving a bribe of approximately 320,000 ringgit to another company, Dilium Primera. And the purpose of the bribe was allegedly intended to ensure Pristine Offshore was awarded subcontract from Petronas Carigali. It was intended for the supply of workboats, crew, offshore support for maintenance and construction services. So what has happened, of course, the company and the individual have both pleaded not guilty to the offenses. The case is still ongoing. So we don't have a first decision yet, to the best of my knowledge. The case obviously serves as a major warning to corporations in Malaysia that the MACC will actively prosecute companies for corrupt acts of their management. And it's a strict liability offense in that sense. The company is liable for the bribe given by its director, regardless of the fact whether or not the company was aware of the specific act. You would still be liable. Your defense, as I've mentioned in court, would only be that you had adequate procedures in place. So it is so essential to have these protective measures, adequate procedures in place to avoid or to prevent your corporation or organization from landing itself in corrupt acts. But if for some reason some rogue individual does that, having the adequate procedures in place is going to save the company from being convicted for the offense.
How do you prove that you have actually taken adequate measures to put in these procedures in place?
That's a brilliant question, Zach. It's a very subjective question, and I think it is also a very difficult thing to answer because different industries, different sectors have got very different nuances to it.
That's right.
So ultimately, what is adequate procedures is something that the court will have to determine. Malaysia has the trust guidelines. You comply with this in a manner that you deem appropriate for your setting of the company. As I've mentioned in the first session, no one size fits all. So what is adequate procedures is a subjective question which ultimately will be determined by the courts upon evidence presented to determine whether or not these procedures are adequate in the first place, such that you would be protected from conviction under the Section 17A offense.
Thanks, Ankit. Now, Cynthia.
Can I add
Sure.
that I think while we are discussing cases already enforced, we should also look at where Section 17A is a game changer. Malaysia is not short of corruption scandals. So we have many lessons now that we do have 2021 and onwards for Section 17A. We could think about how the 1MDB could have been better enforced. We don't have to keep relying on AMLA or Section 16 on gratification and bribes, etc. But we can actually look at Section 17A because many of the testimonies say the decisions were taken without our knowledge. The board needs to know. So this is where trust can actually apply very significantly. So with Section 17A and other related laws, we could help to ensure another 1 MDB doesn't happen. That is the benefit of how corporations need to step up their corporate governance measures.
Thanks, Cynthia. Now, that brings me to my next question. Ankit mentioned that it's quite subjective from industry to industry. And you mentioned that we need to put these frameworks in place. So what should directors do today to protect their organizations, given there's an array of things to comply with? So not just your traditional AMLA, and now we have Section 17A as well. So what should directors be aware of, and what should they do to protect their organizations?
Well, directors, as far as I'm concerned, they should actually see this entire thing, the corruption risk that your company can be exposed to, as a core governance issue within the organization. And this basically means that you must ensure that whatever compliance programs that you may have in place are not just merely adopted, but actively implemented. And it must be monitored, it must be periodically reviewed. Basically, you need to get your hands dirty. You need to be very much involved. As I've mentioned, it's a governance issue. And as a director of the company, you need to understand the business. You need to be able to identify the risks, and you need to create your frameworks and tailor the framework in such a way that the adequate procedure guidelines are met within the needs of your particular organization.
Now, in coming up with these compliance programs, what are the common pitfalls or mistakes that companies make when implementing these programs?
There's a lot of focus now on directors, senior management, etc. Tone from the top comes in about directors learning how to be compliant. They may not even have heard of trust. The government has offered a framework. So within the industry, you can actually work around what would be best for your company. So I don't think the law is so unreasonable or so strict that you can't actually show some flexibility. I think you can, but you have to work within the boundaries of what Section 70A defines. So this is actually very important, because I think it is not really unfair to directors or senior management, but it's about being ready and ensuring that the transparency culture is practiced. There is a declaratory process. There is control measures in place, a whistleblowing channel in case there is a fraud. So some very basic things need to be put in place. And you just need to show that. And it's not about ticking the checklist, but it's about internalizing why that culture is important. So I think the way the authorities investigate is not unreasonable. And importantly, by size of company. So I don't think the very macro SMEs are going to be targeted. I think it's the ones that might be public listed or bigger property companies or any other industry, oil and gas and all that. They're more vulnerable to risks that would be important for them to actually have that kind of code of conduct.
Zach, if you ask me what is the most common mistake that companies make when implementing compliance program, is really treating it just as a compliance process, as a documentation exercise. I think that is the most common mistake that you would hear, because companies often produce extensive policies, but the issue is they fail to embed them into operational practice. So our regulators, the MACC, increasingly focuses on whether the compliance system actually functions. It's no point just having something on paper, having a whole list of extensive policies which are actually not adhered to or are actually not complied with. So putting it on paper is one thing. Ensuring that it is complied with is another thing. And that's what you need to do as a director of a company.
So in that context, the R and the T, TRUST, right, is really essential, because it's not a one-off thing. And there are courses to actually do short review courses on Section 17A. So it is just to remind ourselves and the leaders of an organization that this is a refresher course you need to take. And why trainings are so important, because it's not a one-off training, but you might need to do it annually or every 6 months, depending on how much risk factors get incorporated into your industry. So it's very important that it's a continuous process.
Thank you. And on that note, we will end our part 2 of this Legal Insight podcast on the ESG imperative and how Section 17A and corporate liability for corruption in Malaysia actually works. Thank you so much, Cynthia and Ankit, for joining us today. Thank you for your insights.
Thank you, Zach.
Thank you.
We'll see you in the next episode.